Today's video blog is an excerpt from my new book, Your Multi-Million-Dollar Exit, The Entrepreneur's Business Succession Planner, due out in early 2023. So I hope you enjoy this excerpt and stay tuned for the book. We've been using spousal access trusts for decades to basically set up a trust for the benefit of a spouse and other beneficiaries that can benefit from a gift to an irrevocable trust. It's an irrevocable trust that one spouse creates for another spouse. The spouse beneficiary can be the trustee, and if they are, we have to limit their distribution authority over trust assets to an ascertainable standard, often known as health, education, maintenance, and support. The spouse beneficiary is not allowed to contribute assets themselves to the trust because it would treat it as a self-settled spendthrift trust and may not be recognized for creditor protection purposes. We can also set it up so that the grantor, the creator of the trust, is entitled to be reimbursed for any income taxes that they pay on behalf of the trust. Under a revenue ruling that came out in 2004, the grantor pays the tax for the benefit of the trust and the trust beneficiaries. It's a grantor trust. It's ignored for income tax purposes. And under that revenue ruling, the grantor's payment of the tax is not treated as an additional gift to the trust. What's better than that? In addition, we can set it up so that an independent trustee or a trust protector can reimburse the grantor for taxes that the grantor has to pay for the benefit of the trust beneficiaries. None of these rights will cause the trust to be included in the grantor's estate for estate tax purposes. In some ways, this is known as an intentionally defective grantor trust. The grantor is not allowed to be a beneficiary of the trust, but you can structure these trusts in a way that the spouse beneficiary may, and I emphasize may, be able to have a power of appointment to be able to direct the assets at the spouse beneficiary's death back to the grantor without tainting the trust for estate tax purposes. Depending on state law, like I said, the grantor can get access to these assets. But the grantor also has the power to borrow from the trust if it's structured properly. You can even set up a SLAT, a Spousal Lifetime Access Trust, for each spouse. But there's two things you need to be careful of. One is, we don't want to set them up too close in time because the IRS doesn't like the arrangement where you're just doing trusts that are basically reciprocal in nature and setting them up exactly at the same time with similar assets. They might collapse the arrangement under the so-called step transaction doctrine. There's another doctrine that the IRS has power to invoke. It's under the Estate of Grace case that came out from the U.S. Supreme Court in 1969. And basically the court said, you cannot have trusts that are virtually identical and have them recognized as SLATs. They cannot be reciprocal, in other words. And so we need to create non-reciprocal trusts. How do we do that? There are lots of ways that are identified on this slide. We would fund the trust with different assets on different dates, preferably separated in time by tax years and even by months, not days or weeks. We can give the spouse, one spouse can have what's called a testamentary limited power of appointment to appoint the assets to anybody else that both spouses agree upon. You can even put governors in there to require somebody who is a non-adverse person, somebody who doesn't participate in the trust, to watch over the spouse beneficiary if they're acting as the trustee and exercising this limited power of appointment. You want to have independent trustees involved in these trusts, and preferably a different independent trustee for each trust to make certain decisions regarding distributions not only to the spouse beneficiary, but also other beneficiaries of the trust. You can use a vehicle known as a trust protector not only to watch over the trustees and make sure that they're carrying out their fiduciary duties, but you can give the trust protector certain powers to modify the trust that you can't give to yourself as the grantor of the trust, you can't give it to the spouse as a beneficiary of the trust, and you certainly can't give it to the kids. So this trust protector can exercise powers over the trust that would expand and make flexible an otherwise irrevocable trust. You're going to need to distinguish between the two trusts, Trust 1 and Trust 2. And after Trust 1 has terminated and it distributes the assets after the spouse is deceased, it might set up another trust or trusts for the benefit of kids, grandkids, which could take advantage of exemptions not only from the estate tax, but also the generation skipping transfer tax.